Now let's move on to our next section, a panel discussion on mapping the thriving utility and the mechanism of third-party funding and analyzing of various scenarios which may arise in enforcing arbitral awards where the claimant has been funded by a third party. I would like to invite Zameer Nathani, Senior Vice President and General Counsel, UFO Moviez India, to moderate this session.
I would like to introduce my panelists. So we Badrinath Durvasula, who's the ex-Vice President and General Counsel for HCC Limited. We have Mr. Dilip Massand, who is co-founder and Chief Executive Officer, Phoenix Advisors Limited. We have Srivals joining us, who's the General Counsel and Senior Vice President Legal for Raheja Universal Private Limited. We have Dr. Sharma, who's a learned advocate and arbitrator, Commercial and Maritime, FCIArb London, Honorary Treasurer of ICADR. And we have Mr. Himanshu Dodeja, who's the Managing Director and Head of Legal for Blackstone. All right. The subject we are going to talk about is on mapping the thriving utility and the mechanism of third-party funding in arbitration. While the law of India provides for third-party funding in litigation, the discussion is now that why not expand to third-party arbitrations, funding of arbitration also. The pros and cons, risk and mitigations, whether a law is required or a self-regulation. This is what the elite panel, who's the most experienced panel I've got today, will share with you on the questions they have for the panel discussions. I want to introducing my panelist. Mr. Badrinath Durvasula is a general counsel with substantive experience of 30 years at Reliance Industries, Larsen & Toubro, Adani Group, Hindustan Construction Company. He is involved in many M&A deals, infrastructure contracts, dispute resolutions, arbitration, and litigation in multiple jurisdictions. He will soon be moving to another major corporate in India as general counsel to his valuable service. Welcome, Badri. Mr. Srivals Kumar is the General Counsel and Senior Vice President Legal for Raheja Universal Private Limited, a reputed pan-India developer and real estate group. He has enriching experience as an in-house counsel for 25 years in reputed companies such as Bharti Airtel, Tata Tele, Star TV, Mumbai International Airport, Flipkart, and Rustomjee Group. Apart from the qualifications, he has been a winner of a lot of awards, which include Legal Achievers of 2019. He was also awarded coveted title of Policy and Regulatory Lawyer of the Year 2020. Legal Achievers Award for Professional Excellence and Distinguished Service in sectors was at the gracious hand of Justice Deepak Mishra, Chief Justice then of India. Thank you. We have Dr. Ashok Sharma, a fellow of Chartered Institute of Arbitrators, London. He is a practicing counsel as well as a sitting arbitrator in commercial and maritime arbitrations. He is on the panel of SIAC, ICIA, Commercial and Maritime, ICADR, SFCA. He was General Counsel of MMTC, India's first golden superstar trading house and leading government of India, a $15 billion international trading, having a subsidiary of the company MMTC in Singapore. His track record of 45 years in the legal profession and his membership and his level of member at the executive committee of ICC India and many national and international body, he's been a recognizing face as a messiah of arbitration in India. He's also acted as a consultant to the World Bank of India, and when he was a Chief General Manager Law for MMTC, Dr. Sharma was also awarded Outstanding Contribution to Practice of Law on National Law Day 2008 by the then Honorable Prime Minister Dr. Manmohan Singh. Welcome, Dr. Sharma. Mr. Dilip Massand, he is the co-founder and Chief Executive Officer of Phoenix Advisors Limited. Mr. Massand is Abu Dhabi-based firm which is focused on co-funding of litigation in mature and emerging markets, as well as credit opportunities in the GCC and surrounding areas. Mr. Massand has over 20 years of experience, international experience working with institutional investors, multinational corporations, bank, and ultra high net worth individuals in United States, the Middle East, and India. Mr. Massand previously served as the managing director of SAS Asset Recovery, a Cayman Island firm specializing in complex cross-border litigation. From 2000 to 2009, Mr. Massand served as a counsel and a member of board of DCD Capital. From 1999 to 2000, Mr. Massand served as a general counsel for Massand Group, overseeing civil engineering and construction management across the world. He holds a Juris Doctorate from New York Law School and a Bachelor of Science from Boston University, and is a member of the New York State Bar Association and qualified legal consultant in UAE. He also serves as an advisory board member of New York Law School Alternative Dispute Resolution Committee. My next panelist is Mr. Himanshu Dodeja. Mr. Himanshu Dodeja is a managing director and head lead for Blackstone India based in Mumbai. Mr. Dodeja focuses on mergers and acquisitions, private equity, capital market initiatives of the firm, and on the legal matters. Mr. Dodeja is also on the board of various companies in India. Before joining Blackstone in 2016, Mr. Dodeja was a partner in Cyril Amarchand Mangaldas in Mumbai, where he focused on private equity, M&A transactions, special situations, and advised many other marquee private equity investors. Mr. Dodeja is licensed to practice in India and in New York. With this, I welcome this elite, experienced panel. I've been blessed to have such members from the legal fraternity in my panel. And while we now proceed to the main agenda, before I put questions to my panelists on the set of perspective we are taking on the third-party funding, which should happen in arbitration, to the audience, we are just going to give you a glimpse on it, that what are we talking about third-party funding in arbitration, all right? So what is third-party funding? Countries that permit, one example of a firm offering that, so that to tell you that this is not a new thing, this has been happening. Some numbers, risk and mitigation, some highlight about it, more will be spoken by my panelists. And one case law, just to give you an idea that even if you claim third-party funding as a cost in an arbitration, you are awarded that cost by the arbitrator and courts of law, all right? So going to the first introduction, what is third-party funding in arbitration? Third-party funding is where someone who is not involved in arbitration provides funds to a party to that arbitration in exchange for an agreed return, cover the funded party's legal expenses and fees. In addition to specialized third-party funders, insurance companies, investment banks, hedge funds, and law firms have entered the market. Another recent trend is the development of portfolio funding, where funders provide a funding package that covers a portfolio of cases. Countries that permit or don't permit: US, UK, Australia, Germany, France, Netherlands, London are currently regarded as funding friendly. Ireland in 2017, the Irish Supreme Court blocked a third-party funding for a major case. However, the outlook in Asia, that is Hong Kong, Singapore, is changing, and they have regulations in place and provide for third-party funding in case of litigation and arbitration. This is one of the example. This is a professional discretion. We just want to give you a glimpse of it, that it is available in the market. There is a firm which provides litigation and arbitration funding. There might be many. This is just an example we wanted to bring. This is a firm which is based in Singapore, UK, etc., which provides you litigation and arbitration funding in addition to law firm funding if you're interested in any entrepreneurial skills. In terms of numbers, 2017, the fund available for UK for funding arbitration and litigation was reported 700 million pounds, and globally it was said to be more than 10 billion pounds. So it is happening in big numbers. There are risks involved, which in terms of confidentiality confidentiality and conflicts of interest, which my panelists will focus on. There are countries which are regulating, like for England has a code of conduct for litigation funders. Singapore and Hong Kong requires disclosure, etc., which would be spoken in detail. Coming to the last portion of my introduction, there was a case law between SR and Northcott based in England, where SR was made liable to pay damages for breach of contract with Northcott. Sir Philip Orton, who was heading the arbitration panel of ICC London, found that Northcott had no option but to fund the dispute with third-party funding. The terms of Northcott third-party funding was that if Northcott is successful, the funders would be entitled to recover a sum of 300% of the funding or 35% of the Northcott recovery, whichever is greater. ICC and Section 61 of the Arbitration Act's English law provided for cost of arbitration. Section 59(1) of English law also said that cost of arbitration would include other costs. SR challenged the proceedings. High Court decided that if the cost was incurred for arbitration and it was meant for that purpose, the arbitrator's award was reasonable and the litigation funding was liable to be recovered. So SR's judgment is likely to prompt an increase in the number of successful parties seeking recovery of the funding cost. With the introduction of my panel, with the introduction of third-party funding in arbitration and citing a case law, I now move towards questions to my panelists. While my panelists are speaking on various questions we have put across for you, audience can type in their questions, which will be collated by the organizers. And during the question answer session, we'll be able to address some amount of questions on the time management part of it. All right. So now I begin with my first questions to my panelists. These are the learned panelists we have on the panel. My first question goes to Srivals Kumar, General Counsel and Senior Vice President Legal, Raheja Universal Private Limited. Srivals, two questions. What are your thoughts on the legal landscape in India on third-party funding? And what are the major contractual terms you would see in a third-party funding? 7 minutes is the time limit per panelist. Srivals, you can go ahead. Welcome, Srivals. We are grateful to have you on board. Thank you.
Thank you, Zameer. Thank you for the nice introduction and thanks to the organizers. We are speaking about a very contemporary subject. The concept of third-party funding is not alien to the Indian subcontinent. You know, in real estate sectors, long back, we have seen land litigations, which usually have long gestation period and back-ended profits, which are bought and sold in the unorganized sector by very opportunistic investors from the desperate litigants, which results in the transfer of the very asset in the subject matter of litigation. These informal agreements or hidden arrangement have a risk-reward mechanism and which have been in force for a long time. Having said that, I would say that the British common law doctrine of chamberty and maintenance, the courts in Britain didn't permit third-party funding. However, the Indian courts, right from 1876 in the Privy Council matter of Ram Kumar Kundur, held very nicely by permitting the third-party funding on the grounds of promoting access to justice. So the most important thing which we'll say is that they quoted by saying it is to provide help to those seeking justice, access to justice, which they could not have otherwise afford. You all aware that litigation is quite expensive, is prolonged, so that is required. British court and the common law using the doctrine of chamberty and maintenance for long time didn't agree to this concept. However, there has been a change of the wheel wherein in 2005, in the Court of Appeals matter of Arkin versus Borchardt, the commercial funder group have been recognized. Further, the Australian High Court, which also follows the common law, recognized the legitimacy of funding arrangements in the Campbell's cash and carry case. Having said that, as you rightly pointed out, the Singapore Parliament had codified and permitted third-party funding for international arbitration and related court proceedings under certain conditions and had recognized it under the Civil Law Amendment Act in 2017. Similarly, Hong Kong in 2017 passed the Arbitration and Mediation legislation Third-Party Funding Amendment Bill. These two were specific codified laws which recognize third-party funding. India, on the other hand, yet to have any specialized legislation or codification. But I would like to point out that right across, the judicial recognition of third-party funding has been there in bits and pieces. So the Supreme Court in 1954, in the matter of Mr. G, senior advocate versus unknown, which was reported in 1955, 1 SCR 490, had captured it by saying that it can be accepted at once that a contract of this kind would be legally unobjectionable if no lawyer was involved. So one of the most important concepts that was engraved over there is that lawyers per se, given their, I think, conduct of rules in terms of bar counsel and otherwise, are not allowed to be a sort of a funder in a litigation. Further, in 2015, the Supreme Court, in the matter of Bar Council of India versus A.K. Balaji, clarified the legal aspects of third-party funding in litigation. And I need to quote this, say, there appears to be no restriction on third parties, non-lawyers, I think that's the emphasis, funding the litigation and getting repaid after the outcome of the litigation. So, as we know, the concept of third-party funding is not alien to the Indian jurisprudence. However, we don't have any specific legislative instrument that regulates such funding. So, what we see has been that the Code of Civil Procedure has been amended by few states like Maharashtra, Karnataka, Gujarat, and Madhya Pradesh, which acknowledge the role of financer of a litigation cost for a plaintiff, and they set out the situation where such financiers may be made a party to them. Further, the Allahabad in the UP or Rule 2 also provides that the cost may be secured from the third-party funding of litigation. So these are very good, I will say, presence both in certain ways towards litigation as well as with respect to your, I will say, judicial precedents with unlike this. But what is to be noted is there is no law expressing allowing or banning third-party funding in the arbitration seated in India, nor the Arbitration and Conciliation Act has been amended to build in a mention for third-party funding. So the other question that allows in respect of third-party funding is if this arbitration is funded by an external third party and its arbitration is seated in India or the funder is in India, then the provision of the Foreign Exchange Management Act FEMA may also be attracted. That has to be looked into in detail. Lastly, there has been a favorable reference for third-party funding by Justice Sri Krishna in his report, which was made for the high-level committee formed to review the institutionalization of arbitration mechanism in India in 2017. So we will definitely see as the years progress that there will be a clear codification of third-party regime in India, either through a judicial pronouncement or codification in an arbitration or either in a contract act or in a CPC. So that way we will see there is going to be a major change which we will see over there. Having addressed the first aspect, I would now like to go to address the second aspect, which pertains to the major contractual terms. So like any other contract, there will be some standard terms of a funding agreement, which are going to be revised between the parties based on the negotiating powers. So you have two parties to such a document, between the litigant party to dispute, and there will be the funder. So the first point I would like to say is that the duties of parties need to be articulated very well. Who will carry out the necessary act with reasonable care and skill to cooperate with the funder. The party in dispute needs to request the consent of the funder wherever there is additional cost required. He should report all material events to the funder. If there is a discontinuance of proceedings or a settlement of claim, he should be in touch with the funder. On the aspect of the funder, I believe two important aspects will come. One, he need to release the cost agreed for the financing of the litigation based on the milestones that are agreed with the parties as well as the law firm who is representing them. In addition, there has to be earmarking of sufficient capital for incurring any additional cost if the dispute goes a different direction or there is some development in the case. The most important aspect which I believe is important in such document should be a distribution of proceeds following a successful claim. What would be the waterfall of distribution? How would that happen? right? These are things that are very integrated to each case. The facts will be different. And I think it is not an evolved domain, but I think as we move on, there will be a lot of things that will come over there. One of the most important things which I further feel would be a reps from both the parties. From the litigation party, fundamental conditions include rights of assignment, presence of counterclaims, validity of document, etc. Whereas from the reps, from the funders would be, they say they don't have any interdependence with other entities. So these are more important things. The last two important things which I like to say before I wind up would be that the termination and the consequence of termination needs to be thought through, because this will make or break the entire concept of the funding arrangement between the parties. And not to say the least, the confidentiality and disclosure aspects needs to be kept in mind, because there has to be cases where these issues may have issues in respect of dispute that may happen subsequently. And lastly, data transfer from the funder to third parties require consent, which like in case of a witness, an expert, maybe in insurance companies, that are most important. Lastly, I would like to add one aspect which Zameer introduced during the discussion, was the case of SR, wherein there was a success in the UK court. In 2017, the execution petition was filed for enforcement of the claim in the AP High Court in Hyderabad. However, after few hearings, the matter was settled with the parties and withdrawn. So we can test the waters on how this will happen. So, Sabi, that's my thoughts on in respect of the legal landscape and the major contractual terms. I will be happy to share my comments further in other points as well as the Q&A session. Thank you so much.
Thank you, Srivals. So I think the major points were made is that there are some precedents which are there. Duties should be cast upon rightfully in the contractual relations. There have to be adequate disclosures, confidentiality, conflict of interest. Even otherwise, some risk of recovering the cost, etc., is also affiliated in this business. And termination of the contract and those terms also should be completely aligned in the arrangements. World is working out. Good points were raised by you in terms of the precedents. I go to my next panelist, Mr. Badrinath Durvasula, very experienced senior general counsel in the industry. Badri, there is a precedent which is existing in India for litigation. There are some risk and mitigation factors, like your mitigation can be self-regulation or self-satisfying regulation or law, or there are risks which are highly involved in these transactions, whether your competitor is behind it, etc. These are things which go on. Number one is that whether you would be pro with third-party fund against it, because you are a very experienced senior member. Your views. What are the biggest risks and challenges you foresee in third-party funding from parties to the suit and court? Why not extend? Now, if you have Order 25 Rule 1 of the Code of Civil Procedure, which provides that courts have power to secure costs for litigation by asking the financer to become a party and deposit the cost in court, why not simply extend that to arbitration, and whether you recommend self-regulation or a law for regulating third-party funding, even if that be the case? Yeah, Badri.
Thank you, Zameer. Quite a loaded question covering the whole of the gamut of the third-party funding, but nonetheless, I'll be too happy to share. And first of all, thank you, Academic Times, and thanks to fellow panelists, and also the participants, over about 250 people, to whom my gratitude goes. First of all, why do we need the third-party funding? I'll just build a scenario to bring you onto the page. It's not something of an academic interest. I speak on behalf of the infrastructure companies in India, not to mention any particular company, but essentially I derived my experience from Reliance Industries, Larsen & Toubro, Adani Group, and that of Hindustan Construction. Going through all these companies in the last several years, I've gained certain insights into why the kind of a third-party funding is required. Imagine a kind of an infrastructure company with about 5,000 crore order book, executing about 25 contracts. I'm just making it very simple. There are only about 25 contracts of, let's say, the kind of a holistic contracts or standalone contracts, whatever it be, EPC contracts. But point is that there are 25 contracts, 5,000 crore is the turnover, and the kind of a challenges one would face it. You can safely take, there are bound to be about 4 dispute resolutions at any given point of time. There'll be about 4 arbitrations, and there'll be about 4 litigations which are happening on each of the projects. So that I would say that there are for a 5,000 crore company executing 25 projects, there are going to be 100 the dispute resolutions, 100 arbitrations, and 100 of the litigations which are going on, which is the practical scene which I've gone through in each of these companies which I named just before. So what is the kind of a budget you have to foresee for it? On an average, you have to have a minimum of 100 crore budget going into all these things. I'm talking about a very conservative budget. Actually, when you go into the scenario, it's going to be almost about 500 crores. But let us stick our neck to only about 100 crores at this point of time. So, are you willing to put forth your money, set it apart for the kind of litigations and the arbitrations which you have, which are inevitable and which you will be definitely going about it, or you want to secure it to a third party who would put the money on your behalf? So there are no brainers to say that if somebody can come in and join up in terms of putting a third party funding, I'd be too happy to accept the money so that my kind of a fund allocation to my litigation, arbitration and dispute resolution is going to be substantively hedged. That's a whole key concept. But the point is that how do you really go about it? Is the atmosphere really facilitating, or is it really good to go about it? So coming back to the question, whether I'm a pro or against the third party funding, there are no 2 answers to it. One has to accept it. But with what set of terms the third party funding comes, it's altogether a different terrain. Don't think it's an easy one. As much as the courts are difficult for us, so much of the third party funding terms are also equally to us. I've seen that practically. They're tiresome, they're endless, they're many times frustrating. So this is the ground reality. Now coming back to the point, what are the challenges which you face in terms of going about the third party funding? First of all, remember, in India, the most of the contracts will be dealing with Government of India. So when we are doing with the Government of India, the contest is also with the Government of India, either in arbitration or that of the litigation. Say, for example, you go to the court or you go to an arbitration and then lodge your dispute and go through the process. Then halfway through it, if the third-party funder has to step into your shoes or to handhold you through a particular structure, you need to disclose that to the court or the arbitrator. Or otherwise, the other side is bound to disclose those things to you, because the third-party funding doesn't come as a kind of without a structure. The third-party funding comes as a structure with certain permissions, rules, and regulations. So that information becomes public. Nothing can be hidden. If that is the case, in the courts, one will be challenged that these are the people who have organized somebody else. So we cannot kind of the kind of assignment rights to these people in terms of the court proceedings. Remember, in the court, there are many monies for the infrastructure projects which are stuck in the form of bank guarantees or the bank guarantee releases or the kind of interim releases or a kind of a prayer that is going to be heard as such. So to handhold all these things, it's very difficult for the courts or the arbitrator to accept the third-party funding as it comes. That's the biggest challenge which I have faced hitherto in my life. The second most important challenge is your own financier and the bankers. The bankers and the financiers to your projects are the ones who would like to receive every money that comes from the court or the arbitration into their kitty, rather than the money going into a third-party funder's kitty, and from there it is coming back to them. Obvious, because the financiers would like to have the kind of a right on the money that is receivables on their trade, rather than giving it to a third-party funder. That is the second most important challenge. The third important challenge, the kind of a terms and conditions or the structure which we envisage for a third-party funding itself is so intricate that many a times it becomes difficult for the client, the client to really accept the kind of a challenges, because the third-party funder also knows that it's a long gestation in terms of the courts and the arbitration proceedings. Even if some decision has been taken, it's liable for challenge, etc. So that goes on and goes on. So there is a factor and element of uncertainty which the third-party funder would build into, and accordingly he will tweak the terms in his favor, which the client like me may not be in a position to accept it all through and all the time through. So that's one of the major, the third major challenge. Fourth, your own stakeholders and your own shareholders and your own board of directors. They'll be questioning you all the time that since your rate of, there is normally a kind of an ABC analysis which we do. A is the most strongest cases we are likely to win, and C are the ones which are likely to lose. Every company does this mapping. So when you have a mapping and you know for sure why you go for bucket A or bucket B in favor of the third party funding, please don't go with it, because you will get all your money back. Whereas it is the bucket C where you don't anticipate the kind of a success, that is the one you give it to these people. You tell me, would anybody would accept this kind of a proportion? A basket has to be a mixed basket. For a funder, third party funder, the basket has to be a mixed basket. It's not that only the losing cases he would get or the winning cases the client would get. No, that's not possible. So these are the kind of 4 or 5 major challenges, majorly from the courts, secondly from the courts and tribunals together, arbitrators, and the kind of a board of directors, and the funders and the financial institutions. These are the kind of challenges which we face it. Now, coming to the point, why not extend the third party funding to an arbitration, whether I recommend or not? Certainly, yes, I recommend. In fact, there is no provision which is governing, which obviously indicates that there is a kind of a provision that since there is no prohibition, there is a provision which is available to go for this kind of a route. And if somebody wants to finance it, I would definitely go about it. But having said and having cautiously debated the pros and cons of it, it's not always in Indian scenario. It's not always a very encouraging step to go for a third party funding. No doubt we need to test the waters. In India, we have not tested much, and it takes a little more time for us to really test and go about it. That's all I would like to say in my first lecture. Thank you.
Wonderful. Very nice. I think good perspective. So while Srivals said on precedents and risk involved, you were saying that there are tough terms which are given by the third party funders. There is a question by the board at some point of time. There's a trouble with the courts accepting that and the arbitrators accepting third party funding. So maybe if these things are sorted out, then we could get aligned with the global world, which is getting into the third party funding. Obviously, there are some self-regulation like we spoke about for England, and there are regulations in Singapore, Hong Kong, and other places towards the disclosure of the third-party funders, as well as that the third-party funders would not influence that proceedings. So maybe keeping that in mind, I now move on to my next speaker, who is into the business funding, and therefore, he is the chief executive officer and co-founder of Phoenix Advisors. They are into co-funding businesses, and who can be the person to tell you that, do you get tough terms, or are they aligned to have this process set into the process of the global scenario? Because if third-party funding is made on the basis of arm's length, is made on the basis of reasonable terms, maybe third-party funding could be promoted, because there are genuine litigants who would like their arbitration to be funded because of the financial position, and they would like to provide good terms to the third-party funders subject to some control. I go to my next panelist, Mr. Dilip Massand. Dilip, 3 questions to you. Why is India getting so much attention from third-party funders? What are the criteria on which a third-party funding makes a third-party funder makes a funding decision? What concerns do funders have regarding funding domestic legal matters in India? Dilip, all yours. Welcome to the panel.
Thank you very much, Zameer. Thank you, and good day to all my fellow panelists, and thank you to the Economic Times, and thank you to all the attendees. I wish we could all be in person together, but obviously we can't. Turning to the questions, Zameer, why is India getting so much attention from third-party funders? Let me give you the perspective of someone who happens to have the luxury of sitting in a time zone where we can see Australia to California in 12 hours. And has been in this industry for 10 years. So look, I think we are seeing a convergence of factors, and clearly India is at an inflection point. Right now, one, there's a tremendous amount of capital that has come into the third-party funding asset class. It's a non-correlated asset class, and money has come from hedge funds, family offices, and even here in Abu Dhabi, several sovereign funds. So you have an asset class that has a great deal of liquidity. A lot of that has come into the London market. So you've got quite a crowded market in my sense in London. And essentially the UK is a small market. So the UK funders have to get out and find more opportunities. Australia itself now, there's more regulation coming down on funders because there's been so much class action in Australia. So when you have this push from the UK and Australia, from an arbitration context, you end up in Singapore, an easy jurisdiction for both markets to access. You get to Singapore, you look at the new arbitration laws, and the minute you start looking at funding arbitration in Singapore, you start seeing a lot of Indian matters and matters involving Indian claimants. And they tend to be quite large infrastructure projects and infrastructure disputes. As soon as you do that, you start engaging with Indian lawyers. And the Indian lawyers educate you about the dynamic changes in India. And you see there's a new bankruptcy law in India. There's a new arbitration law in India. So that becomes interesting to look at. So that's one set of factors. The other thing I would say, you've got India is tremendous with its intellectual capital. And you have a generation of young professionals that are actually getting out there and spreading the word about third-party funding and India being an opportunity. This is the fourth panel this year that I've been involved in around the globe that India is a subject. And I've seen panelists, I've sat on panels with people from Himanshu's old firm, Cyril Amarchal Mangaldas is leading the charge. You've got people from FTI Consulting who are experts on quantum, who are in other jurisdictions talking about India. And you've got some great people from MZM Legal as well, who were in Hong Kong recently talking about India. So that energy is getting out into the world. I would tell you that, the other thing too is these new laws. With the new bankruptcy code, the new arbitration code, you have hedge funds and credit investors looking at India. Litigation funding is a subset of credit. It is non-recourse credit. And that makes India really interesting to see, as Badri was talking about, the HCC transaction, it woke up the world. As soon as we saw that funding, I can't tell you how many funders emailed each other saying, did you see? So I don't know at what point you lost me, but I was talking about the new bankruptcy laws and the new arbitration laws and credit investors and litigation funders both being woken up to that. And the other thing is, from Abu Dhabi, we define our market as Africa, India, and the Middle East. India is 2 hours away. We have a lot of capital that flows into India, so we have to have an India strategy. So for those reasons, I think, and India is a big market, it's on everybody's radar. You have to have an India strategy these days. In terms of the second question, what are the criteria on which a third-party funder makes a funding decision? We have in the industry what we call the 4 pillars of funding. And in the Indian context, I would tell you there's a 5th pillar. So the first one is merits. Is it a good case? Does the case have merits? Second one is jurisdiction. Do you like the jurisdiction? You know, in the UAE, we have onshore, offshore, Sharia. In India, you have the Indian jurisdiction. Are we comfortable with it? Now with arbitration, you have a new set of laws. You have a new arbitration center. The jurisdiction is becoming more attractive. Then there's quantum. I think Badri pointed out that funding can be expensive and the risk has to be priced in. So from a quantum standpoint, back of the envelope, what you want to see is a claim amount that is 10 times the funding request, because a funder will ask for 3 times their money. So there should be money left, 60%, 70% should go to the claimant. In other jurisdictions, the law firm will also take a percentage. So you want to see a 10-to-1 ratio from the requested funding amount to the claim amount. And then the fourth one is collectability. You can have all the rest, but what's the point if you can't collect? And so you have an arbitration award. How am I going to enforce that award? Where are the assets? How long will that take? That brings us to time. There's a time element. Have I told my investors that I will give them a 5-year return or a 3-year return? So these are the factors and the criteria that I would tell you the overwhelming majority of funders look at. Lastly, what concerns do funders have regarding funding domestic legal matters in India? I think in a very broad context with India, in any investment, you look at how do I get my money in and how do I get my money out? And there's quite a bit of uncertainty about that. We would like to see a clear regulatory regime in India. What is the structure? Do we go through Mauritius? Do we go through Singapore? Do we have to set up an NBFC to fund matters in India? Do we partner with an NBFC? How is the Reserve Bank of India going to treat this income? Are we going to end up with a tail tax issue 10 years down the road, which is going to be problematic for our long-term business interests? And then you have a currency issue. You have a fluctuating currency. Funders right now like to be in dollar-pegged jurisdictions or a currency that's not going to fluctuate as much as the Indian rupee is. So those are some of the concerns. And then in the arbitration context in India, we have been on the ground in India looking at these infrastructure projects. Ultimately, you're going against an arm of the government of India. So the issue becomes, will we be successful with 1, 2, 3, and now the laws will change? And what happens? We want to build long-term businesses. We're not looking for a quick hit. So that is an issue vis-a-vis arbitration in India. I think really that's pretty much everything I have to say about this. And I think maybe I was well under 7 minutes, so I apologize if I was too quick on the draw.
Great presentation, Dilip. I think you were trying to basically, address. I thought it's an answer to Badri's questions also. So while Srivals spoke about that there are precedents in law for litigation, funding, etc., and there are some risk associated with it, Badri said that terms are very tough. Both questions, as there's a question from courts, there are questions from arbitrators. And you said that the terms may be tough because there is an uncertainty to it. We have to look at the merits of the matter. You have to see the jurisdictions to it. You spoke about 10-to-1 ratio. You were more comfortable on the collectability, good collectability side of it and dollar peg. So those are jurisdictional concerns which you have as a funding institution if you want to go ahead with a third-party funding for arbitration. So that's the perspective which you bring in. To proceed to my next panelist, who one of the most experienced counsel and arbitrator, 45 years of experience in the background. He's been on various panels and institutions. Dr. Sharma, welcome. 3 questions to you. According to you, what are the major gaps in the Indian legal ecosystem for third-party funding? Why are we not able to connect the dots? Number 2 is that, are there any major ethical issues involved in negotiating a third-party funding arrangement with a funder? And do you see, remarkably, Indian PUCs opting for third-party funding in future? Why not? And if yes, then do you see that particular scenario? Dr. Sharma, welcome. Please proceed.
Thank you, Zameer. Thank you, fellow panelists, and thank you, Economic Times, for giving me this opportunity to share my thoughts. I'll quickly move on with my presentation because the time is less. Indian market is now ready for this disruption of third-party funding in litigation financing. Indian arbitration market is maturing after the 2015 amendments. Indian arbitration regime has been improved considerably. It has been brought at par with the other arbitration regimes. But then there are some gaps in Indian legal ecosystem, which need to be taken care of before the the third-party funding can really, find its place in India. First gap, according to me, is that class actions by and large are not there in India, which is a very attractive proposition for third-party funders. Only recently in the Companies Act amended in 2013, class action for shareholders have been brought in by bringing in section 245 and 246, which was after that Satyam scandal. And now shareholders can file class actions. Otherwise, this class action market is a very nascent stage. So this is something which needs to develop to make India as an attractive market for third-party funding. Secondly, when the third-party funder takes a decision to fund or not to fund, it would require historical data, which in India, in the case of India, is practically non-existent. So that is one handicap which a third-party funder will have. And third is that roster system in Indian courts, Indian high courts, practically all the high courts have that roster system, and there are frequent changes in that system, which leads to delays and unpredictability. How much time a case is going to take in high court, whether it will be 2 years or 5 years or 7 years, it is very difficult to predict that. You really need a crystal ball to really accurately predict that. And one important area, normally the third-party funder, when it switches the deal of third funding, the lawyers' fees on contingency fee basis is really factored in so as to bring the cost down for the third-party funder. But that is not possible in India. Our Bar Council rules prohibit any success fee-based arrangement with the client. So the Indian lawyers cannot, agree for that. Now, because our legal lawyers are still governed by an Advocates Act of 1962, which is something which really needs to be changed. Although the government had appointed a committee to go into that and suggest amendments, but so far nothing has been done. Until the time that is done, it will not really make the proposition very attractive for the third-party funders. Both lawyers and corporates, they are under pressure, especially these days, to innovate and manage costs. And third-party funding is definitely a tool to manage risk and cost for the corporates as well as for the lawyers. And to take advantage of this, India has to come up with a regime. Like Singapore and Hong Kong, they have done. Singapore has, in 2017, has done away with this doctrine of champerty and maintenance by passing a civil law amendment. So similarly, in 2017, Hong Kong followed suit. Now, it is very interesting to note that both Singapore and Hong Kong, they have done away with this champerty and archaic doctrines of champerty and maintenance in 2017, when China was, coming out with their Belt and Road cross-border infrastructure project, which is, which is a very ambitious project of China, and it will generate a lot of disputes. And both the countries have done, they have got themselves ready to take on that bulk of disputes which are going to come there. And they have come out with the rules for third-party funding also to make third-party funding a very attractive proposition for their clients. So similarly, India also, needs to do something on time is now right. It is an idea whose time has come. And Indian government has taken many steps for ease of doing business. And I think this is one step which now I think needs to be taken by the government. As regards the ethical considerations in TPA funding, quickly I'll say that interests of litigating party, lawyer, and the funder, oftenly they are at divergence with each other. Funder wants quick results, and whereas the party wants results for its litigation. And these interests, can become a little more divergent when the funder tries to, put himself in the driving seat. And then in case some settlement comes, then timing and value of that settlement also become a point of issue. Because if that amount is little less than what the funder can get by pursuing the litigation, then the funder may not be interested in settling. And that can be a point of friction between the litigating party and the funder. Plus, then there are confidentiality issues because when the funder has to take a decision, the litigating party has to provide him with the information which is privileged information relating to the litigation. And for that, there has to be proper non-disclosure agreement signed with the funder. And at that conflict of interest disclosure, that is a very important component that has to be disclosed in the courts, arbitration, and courts both. Hong Kong has framed a code of conduct, code of practice for third-party funders, and they have set up an advisory body also to ensure compliance with the code. Singapore Law Society and their Singapore Arbitration Society has come out with guidance in this regard for the parties as well as the third-party funders. Their system is quite regulated. So in India, we also need to come out with a regulatory regime for the third-party funding before it really takes off in the Indian context. As far as PSUs are concerned, I'll just take 1 minute, and then I'll finish off because we are running out of time. I know. As far as PSUs are concerned, by and large, PSUs being the government body, companies, they are conservative in their approach, and perhaps they would like to wait for the regulatory regime to come in place before they really get on with the third-party funding. But then definitely it remains a very attractive proposition for them. Thank you.
Okay. Thank you, Dr. Sharma. I think the moot point what you made is that if there are regulations which are available in the world, which are either through the laws which are already available, or if there are self-regulation mechanisms which have been followed by institutional arbitrators and arbitration bodies, why not have a look at it and adopt and customize to the Indian environment so that there is a possibility of a third-party funding where we also take care of the risk and we try to mitigate the risk, but we are in line with the world and we strengthen ourselves on that particular basis. That option is available under the law. All right. Thank you very much, Dr. Sharma. My next panelist is actually from the investment side of it. So Blackstone is a highly reputed, globally known investor. How does an investor think on these lines of third-party funding? My questions to Mr. Himanshu Dodeja, Managing Director and Head Legal of Blackstone India. Himanshu, how do we see this asset class as a foreign investor or a player in India, and what are the challenges involved? How do we view third-party funding in India in comparison with some of the other Asian countries, because you also do comparative analysis? What would be a foreign player like to see before having a positive point of view on this initiative of third-party funding? Himanshu, the dais is all yours.
Yeah. No, thank you, Zameer. Really appreciate this. And I must say, my job is actually quite easy. Earlier, when I thought that I'd be the last speaker, I was very unhappy. But now knowing I've had the privilege of everybody having spoken to me before, Mr. Ashok Sharma, Dilip, and a bunch of other panelists, I think my job is relatively easy, and I will try and keep it short because I know it's lunch. Thank you. So very quickly, without getting into every detail, let me just talk about our perspective or my personal perspective, personal view on this topic. Insofar as the topic is concerned, I agree with everybody on the panel that it's indeed the most important topic now in the current circumstances, especially when we are seeing, the Indian corporates not having enough on their balance sheet, and trying to take care of large litigations, arbitrations, especially outside India. So it's a very, very relevant topic, more importantly in the current circumstances. That's the starting point. Insofar as the industry is concerned, it's a large industry. The number is somewhere around $150 billion plus and minus. Dilip would know that better. Bloomberg has said it several times that litigation financing has outperformed some of the other classes such as private equity, real estate, and debt. I continue to believe that it's a very small sort of data to really compare it with real estate and private equities of the world. But for whatever it's worth, it's definitely an asset class which has performed reasonably well outside India and outside Asia to start with. So, and insofar as India is concerned, people are again pegging this to be a $50 billion to $70 billion industry, especially when we have large arbitrations in India and outside India. You require large capitals from Indian corporates, and which is one of the bigger problems for Indian corporates, because when they are up against foreign institutional buyers, and perhaps I'm talking against my own interest, when we see an Indian party on the other side, one of the major advantages that we have, or any foreign investor would have, is that they are very comfortable spending a lot of money on legal, which Indian corporates are not. Even if they have money, they would not want to spend 30% or 40% of the contract value in the cost of arbitration, which is what empirically the numbers suggest. And number two, even if let's say they have a great claim, sometimes they know that they do not have the financial muscle power or the financial wherewithal to really withstand large arbitrations. So clearly, this is an area which we really need to talk about. This is an area which has to do better. This is an area where Indian legislative system should also be coming forward and having an active debate on. So that's on the industry per se. Now, do we feel great about it? Do we, as a financial investor, or speaking on behalf of Dilip, would they really jump on it, given the kind of opportunity we are seeing in India and how large the industry is? Unfortunately, the answer is no. And I'll be straight here for the following reasons. Firstly, if you see, there is no law regulating it. You have Supreme Court judgment, you have CPC provisions, you have, then Advocates Act, the Bar Council rules. Laws are endless, and these laws are archaic. Being an Indian, I don't want to make that statement, but that's the reality. We need to appreciate that first before we really find a solution to it. Unless we understand what the problem is, the solution is not going to be optimal, right? So to start with, I think we need to have a law that Mr. Ashok Sharma also talked about what we are seeing in Singapore, that they have come up with the regulatory process, they have regulated the funders, they have recognized the ability of the funders, they are going in a very staggered way. They're not saying that you can actually get funding for anything, for your defense claim, to your class action, to your criminal case, to international arbitration. What they're saying is, let's start with the arbitration, large contract values, large amounts involved. Let's start with it in a staggered way, see where it takes us, and then we will open up to the rest of the areas, whether it's buying of claims, whether it is tortious liability, whether it's class action. None of that exists today in India, actually. Look at the kind of compensation you get in the consumer cases. Like, less than, even if somebody dies, the maximum compensation you'll get is not even a couple of $1 million. The maximum, what I understand, is a couple of $1 million, and that's about it. That too, after protracted litigation of 7 years. So that is point number one. We need a clear law regulating this. And the reason for that, I know we have Australia, we have UK, but they are from Mars insofar as this topic is concerned to start with. Let's be very clear. We are a developing nation, A. B, our enforcement of contract. Just to remind everybody here, on enforcement of contract, it takes almost, on an average basis, 5 years before you actually get a first degree on the enforcement. I'm not even talking about appeals, and I'm not talking about further actions. And more importantly, if you see the enforcement of contract itself on a global map, we are on 163rd position out of 189. And that is because of lack of data, lack of, we have less number of judges. We, of course, require judicial reforms for it, but we need consistency. We forget about Delhi High Court being different from Bombay High Court. Delhi High Court itself, the moment the bench changes, the roster changes. Yes, the moment the bench changes, I'm saying forget about, I understand in the US, in the UK, people talk about, whether it is the first circuit to the second circuit, what is the variation? But here you talk about Delhi High Court, and I'm saying within Delhi High Court, you would have 5 patterns for the same set of facts. People would say, if these are the facts, this judge is likely, again, I have deepest amount of respect for the judges. This is nothing personal. This is just the way how we function. Let's be clear about that. I think we've got the finest judiciary in the world, and we have to really make the most out of it. Like if you look at the kind of pronouncements we have, they're unparalleled. The reason India continues to do the best in Asia is because one of the basic reasons is the rule of law, is the court system that we have. It is slow, but it is never wrong. You go all the way to the high courts and Supreme Courts, things are great. But having said that, as I said earlier, that we need to recognize the fact that unless we come up with clear law, really discussing what is the scope on disclosure, what is the scope on conflicts, how are you going to become a party before the court? CPCs have been amended, but certain states have been amended. So in short, I think we need consistency, we need a clear law, and we need a clear political will to recognize that this is a topic which will help, not the foreign players. Just to be very clear, yes, we may make, or people like Dilip may make some money, but at the end of the day, you are dealing with the substantive rights of the Indian corporations, which will get protected to a very large extent, especially in the context of international arbitration, right? So in short, as I said, I'm standing between lunch and the audience and all my panelists. So let me say that if we have 3 or 4 things going forward, I think it'll do a world of wonders. Number one, I'm grateful to the Supreme Court that Supreme Court has recognized that third-party funding is a legitimate way. So tomorrow there cannot be challenges on account of public policy, that it is unconscionable, it is unsustainable, and so on and so forth. And coupled with the fact that CPC have been amended again to allow third-party funders to become parties, and so on and so forth. But I think we need to do a lot more than that. As Indians, unless we are regulated, we are completely unregulated, if you know what I mean on a lighter note. Because if you're not regulated, it means, yeah, I can do anything I want. It becomes banana republic to a very large extent. See what is happening to the gaming sector. Today, if you ask people around that, do you know whether the gaming sector is open to a financial investor, or it is permissible? Supreme Court has passed a judgment saying it is a game of skill and not a game of chance. Now, that is a debate that nobody can win, ever, let alone a financial investor, a foreign financial investor, in terms of how to really dissect that statement, what is a game of skill or a game of chance. Again, you have state subjects, but unless you have a unified code of law in some form or the other, again, I'm not saying over legislation, but some sort of legislation recognizing these facts, making amendments to the tax laws, very important for a financial investor, because when we come in, when we go out, is there going to be GST on it? Is there going to be withholding tax on it? That is an important area to be addressed. Changes in the Arbitration Act, recognizing the fact that the third-party funder can come in. And lastly, one of my panelists talked about FEMA provisions. Today, again, there is less clarity. There is no clarity whether it is a capital account transaction or a current account transaction. Now, when you talk about some of these very basic items, I really wonder, and as we talked, that this requires large amounts. We're talking about $50 billion to a $70 billion, kind of industry. Unless you have some of the basic hygiene stuff there, I think it's a great academic topic till then. So I will stop there. I think it's just about 7 minutes. Back to Zameer.
Yeah, thank you. So, you gave a very clear point of investor perspective. What is the clarity you are expecting? So how I would summarize is that where Srivals said that there are precedents in litigation, Badri also expressed that, there are tough terms to deal with the third-party funders, where they made an expression that, these are tough terms because there is an uncertainty to it. Where Dr. Sharma said that if there are regulatory things which are available in other country, why not adopt, adapt, customize so that we can inbuilt into that? And from your perspective, Himanshu, you said that, we need clarity in terms of law so that we can decide on the further course of action, because this involves a huge amount which is there. You also spoke about litigation funding, which has outperformed some debts, which a minimalistic study, what you referred to. But you spoke more on the clarity of law, which is required, as also the taxation law, so that third-party funding could become a reality in India. With this, I thank all my panel. You were great. This was a great insight from a 360-degree point of view. I now go towards the question-answer session. We've been bombarded with questions. We've tried selecting those questions. We are sorting out as we speak here. Panelists can just raise your hands and chip into to answer those questions. Every question, let us restrict to 1 minute so that we can take some more questions. I'll be citing 2 questions together so that we can take maximum questions in that limited time. My first question is, are there instances, these are questions which have come from the audience, are there instances of dispute between the third-party financer and the party to the underlying dispute availing such finance? In case of such dispute, can the party providing third-party funding seek a stay order regarding the arbitration or litigation proceedings? And what is the minimum ticket size that the third-party funders usually look at? Any of my panelists can go ahead with.
So,
Yeah, Dilip.
Thank you. So in terms of dispute between the funder and the claimant, to my knowledge, and right here in the UAE, there's a famous case called Karafi versus Vannin Capital out of the UK. Vannin Capital funded the Karafi family's case against Bank Saracen for mis-selling. And they were successful in that. And an award was rendered against the Swiss parent of Bank Saracen. Money had to be paid into the DIFC court, the Dubai International Financial Center, and then distributed under the waterfall. The Karafi or the claimant did not honor their obligation to the funder. The funder brought an action to actually have those proceeds held in the Dubai court, and then they had to have a litigation with the claimant for another year plus in order to get their money out. So we did not see an instance where a proceeding was stayed, but we saw an instance where there was a dispute between the funder and the claimant over the distribution. And that is something that the funding world watches closely, and another reason that terms are very stringent. In terms of minimum investment, I would tell you there's a lot of work that has to be done on diligence of these matters, particularly in single case. You've got your own team of in-house lawyers, you've got underwriters, you will use outside counsel depending on the jurisdiction. So for each funder, there's a different element as to how much time did I put in and what should be the minimum quantum. Again, from back of the envelope, I would tell you the larger funders won't do anything below $1 million because of the time that is spent. We might be a little more opportunistic. We might, and the other thing too is if there is a law firm that is willing to put their fees on a contingent basis, then that will move a funder below that threshold because there's a sharing of risk. So that's all I get. That's what I'd like to add on those 2 points.
Okay, thank you, Dilip. The second question goes is, what is the
Zameer,
option available? Yes, sir.
Srivals here. Can I just answer this question in respect to the dispute from an Indian context?
Yeah, please go ahead, please.
So I see two different disputes in place. One is the primary dispute for which the litigation party took some third-party funding. So that goes on parallelly. The only thing that the funder can do in Indian context, depending on what is the clause on jurisdiction and disputes, would be to get an interim stay so that the litigating party is not able to take the claim or the successful amount it gets from the primary dispute into its own use. So only they will get a stay. That's one. Second to note is that when is the dispute coming? Is it coming during the pendency of the primary dispute, or it comes at the later stage when the successful claim has happened? So on factors based on that, I definitely believe that the best option for a third-party funder is to get a protection from the court just to get that claim not to be disbursed to the successful party. Secondly, on third-party funding, the ticket size, I think it will vary from party to party depending on the aptitude they have. They look at the facts of the case, and I think it will be different for different parties. Thanks.
Yeah, so appreciate that. I think that was a good perspective from an Indian context point of view, because of the funding diversion, etc., which issues you really pulled up. The next question is, what is the option available for delay beyond 12 months to decide petition under Section 34 as mandated in 2015 amendment of the Arbitration and Conciliation Act? NALSA being unable to effectively monitor non-provision of legal aid by various courts up to Supreme Court, what is the remedy? Execution of arbitral awards generally getting delayed at district courts even without a stay. What could be a remedy for the awardee? Anyone would like to go
This
for
question
it?
fall outside the topic of our discussion.
Yeah, so we have restricted our discussion to third-party funding because there we want to point out what are the do's and don'ts of it, and we want to keep it to that because these are offline discussions. Supreme Court apparently being impressed by appearance of AG and SG seeking fourth time on. I think this is also one of the other things which are happening. Are there instances?
We address this.
Yeah, this has been already given. In some cases, third-party funding is like gambling. So this is the word of the question. Do you think rather than avoiding dispute resolution, it will put even more burden on the already overburdened legal system of India? Badri, you want to take that?
I don't call it a gambling. I don't agree with it. Third-party funding is a very sacrosanct kind of an instrument. I think it's being looked at very seriously and very considerately. And one day or the other, it needs to come into the Indian shores. So it's not a gambling, but definitely it is a wealthier proposition. Every corporate in India would look at it. So this is a very serious topic. It's no more a gambling. Second is that the second aspect is the alternate dispute resolution. Why it is not succeeding? I think that in India, most of the contracts are awarded by government, and the government mechanism itself doesn't subscribe to the kind of alternate dispute resolution. It doesn't go through the mediation process many a times. It wants to precipitate either in the arbitration or that of the litigation. That's a primary reason for 60% of the disputes originating from the government sector not to be settled as such.
Absolutely. And just to clarify that third-party funding, what we are talking about is there in the provisions of the CPC in terms of litigation. And here we are talking about contractual relations. Here we are talking about regulations. There are regulations in various countries which require disclosures to that. So we are talking about a legal process which can be either self-regulated or brought into the law so that there can be a third-party funding in arbitration. All right. My last question.
Despite all these inconsistencies or the kind of lack of domain, the kind of an expertise which we all discussed about it, still there are proposals, still there are considerations, and quite a few number of parties are already discussing. Given this set of limitations, I think that's something which really speaks about the India going forward into the next millennium.
Absolutely. And I agree with you that there are some risks which are associated with that, but we are also looking at mitigation of those risks. So while there are uncertainties, we are also looking for certainties to have third-party funding in arbitration. My last question to of the panelists who can take up. In order to promote third-party funding in India, would it be correct to say that the first step is to institutionalize arbitrations in India as opposed to heavily practice ad hoc arbitrations in India? Any of the panelists can take up. So Himanshu can take up, Dr. Sharma can take up, Dilip, or anyone.
Srivals here, Zameer.
Yeah.
Do you want to speak?
Ashokji, you can carry on.
See, for third-party funding to take place and succeed in India, what we really require is a framework by way of legislation to be put in place for regulating third-party funding in India, as it has been done in Singapore and Hong Kong. In UK, yes, they are self-regulating kind of framework they have. But in India, we really need so as to, avoid the uncertainties. Because otherwise, some party will go to court and make allegations of it being against public policy and all, and that whole thing will get stuck. So far, we don't have any definitive decision on that. That High Court, Hyderabad, the High Court execution petition, which was where this was one of the points that it is funded by a third party. That has been amicably settled. So we don't have any decision in that. And even the Supreme Court's observation on third-party funding in A.K. Balaji's case is only by way of obiter. We really don't have a case which has really dealt with this third-party funding question as such. So a regular framework is really what is really required by way of legislation.
Okay. So we have just 30 seconds, Srivals, if you want to add anything.
I just like to highlight and say that the whole concept is the regulatory framework. We will go through iterations of version 1, 2, 3 by which we mature the system per se. But definitely, I believe there is a lot of scope for third-party funding in India, more so with huge stake, high-stake litigation. So definitely framework with and also support from the professional legal professionals and arbitrators, we definitely will see light at the end of the tunnel. So that's my closing remarks.
Thank you, Srivals. I think that's what we are. So if the world has adopted the system of third-party funding in India, if the legislation provides under CPC for litigation, and if there are obiter remark by Supreme Court of India, why not have a self-regulation or a regulatory framework for third-party funding in arbitration, so that there is a certainty, it benefits genuine litigation where funding is really required, and we have third-party funding in India for arbitration, which is regulated and flowing, and it really also benefits the industry and overall governance about arbitrations. So this is from my side for the panel. We had distinguished panel with us, all elite experienced panel with us. I would like to thank Economic Times, thank the business head of Economic Times for organizing this event. Team of Economic Times who have spent a lot of time and efforts, hard work and dedication. We were at the Economic Times ADR Legal Conclave 2020 virtual conclave. I would like to thank and express my gratitude to Justice Deepak Mishra and Justice Radhakrishna, and thank my panelists for giving such distinguished views, and thank the audience for patiently listening to us. This was all about third-party funding in arbitration. Thank you very much from my side. Thank you.
Thank you all.